Good morning to one and all present here. I, Nisha Shah, extend a warm welcome to the one-day online national conference on inclusivity in law, multidisciplinary perspectives, organized by SVKM's Praveen Gandhi College of Law. Praveen Gandhi College of Law is an institution under the aegis of Sri Vile Parlikhilavani Mandal and is affiliated to the University of Mumbai. The hallmark of this institution is the adoption of a holistic model of education dedicated to the pursuance of quality education with the objectives of resource generation and knowledge pooling. The idea of the conference was an outcome of these objectives. Thus, on behalf of Praveen Gandhi College of Law, I present to you the Conference on Inclusivity in Law, Multidisciplinary Perspectives, with the purpose in mind to welcome diverse perspectives on understanding the concept of inclusivity under the subject of law through several disciplines and its allied fields. Now, I would like to invite our in-charge principal, Dr. Naushikha Duara, to address the gathering and to officially mark the commencement of the conference. Over to you, ma'am.
Ma'am, you're on mute.
Yeah, sorry. Hello, good morning, everyone. In the beginning, on behalf of Praveen Gandhi College of Law, I extend a warm welcome to everyone present here. I offer my sincere welcome to Justice A.P. Shah. We are indeed honored and grateful to have you with us. Thank you for accepting our invitation to deliver the keynote address to the conference. My sincere welcome to Professor S.M. Michael. Thank you, sir, for accepting our invitation and giving the introduction to the theme of the conference. I also welcome all the distinguished guests, resource persons, participants, paper presenters, and dear students and fellow colleagues who are going to participate in the one-day national conference on inclusivity in law, multidimensional perspectives. Like my fellow student volunteer has already pointed out, in Praveen Gandhi, we have been always striving to create an inclusive spirit in the minds of the students, whereby we try to achieve not only academic excellence, but also try to fulfill our obligation as a law college in creating responsible citizens. With that objective in mind, we carry out, design different activities. The national conference, which is organized by the college annually, is one of the events that has been designed to achieve that objective. This year, the theme is inclusivity, and the three areas that has been taken up for deliberation is gender inclusivity, educational inclusivity, and the last one, but to me, it is probably the most challenging one, how to get our fellow citizens, our brothers and sisters who are specially abled into the inclusivity fold. Before I conclude my welcome address, I just want to share a thought of mine with the esteemed gatherings. If we talk about inclusivity as a concept which includes acceptance and accepting each and every individual for who they are, what they are, and respecting individual differences, then can we think of creating a real inclusive society without developing the spirit of inclusivity in the minds of each and every member of the society? To me, only when we are in a position to develop the spirit of inclusivity in us, within ourselves, we'll be able to create a real inclusive society. Only then we move a step closer in creating a democratic society, which the makers of the Constitution of India had definitely in mind when they declared India to be a democratic republic. With this, I conclude my welcome address, and I'm sure we'll have a fruitful deliberation and discussion on a very challenging topic like inclusivity. And now I officially formally announce the opening of the conference proceedings, and thank you once again to all the distinguished guests, and welcome once again on behalf of Praveen Gandhi College of Law. Thank you very much. Over to you, Janisha.
Thank you, ma'am, for your words. They couldn't have been more encouraging to begin the conference with. I now request my co-hosts Sakina and Yashesh to take over. Thank you all.
Thank you, Janisha. Good morning, everyone. I'm Sakina, and I take the immense pleasure of introducing our keynote speaker for today, Justice A.P. Shah. Completing his graduation from Government Law College, Mumbai, and gaining experience in
Sakina, you have some issues. Can you please adjust your mic?
Hello.
Now it's perfect.
Okay, good morning everyone. I am Sakina and I take the immense pleasure of introducing our keynote speaker for today, Justice AP Shah. Completing his graduation from Government Law College, Mumbai and gaining experience in civil, constitutional service and labor matters, Sir was appointed as an additional judge of Bombay High Court in 1922, later becoming a permanent judge of Bombay High Court in 1994. Sir assumed charge of the office of Chief Justice Madras High Court in 2005 and on transfer took over Chief Justice Delhi High Court on 11th May 2008. He retired on 12th February 2010. He is the former chairman of the 20th Law Commission of India. From successfully advocating for the rights of AIDS patients in employment to initiating prison reforms, Sir's judgments have always been hailed landmark. Some of important judgments were based on freedom of speech and expression, women-related laws, environment and ecological matters, protection of disabled persons, PIL, decriminalizing homosexuality, RTI Act, and pro-poor rulings. Justice Shah directed various steps for computerization and networking of all courts in Tamil Nadu, including introduction of touchscreen kiosks and digital boards. Sir was also instrumental in organizing the programs relating to sensitization of judicial officers, judges, family courts, and judges regarding gender justice and juvenile justice. Sir bolstered the mediation movement in Maharashtra, recognized the movement of Lok Adalat, and also started Pension Lok Adalat. So we are truly grateful for taking your precious time to join us for the conference today. I now invite Sir to address the gathering. Thank you.
Yeah, Sakina, can you hear me? We'll take a few minutes. We are trying to adjust the technical functionalities for Sir's video presence for the conference. Yeah. So our attendees are requested to wait for a few more minutes before we have the pleasure of listening to Justice AP Shah. Thank you.
Actually, Sir doesn't have the access right now. Jeet, could you look into that? Yes, sir. Yes, sir.
Can you hear me?
Yes, sir, we can.
Yes, sir, we can.
Can you see me? 1 minute. Can you now see me?
Yes, sir, it's a pleasure. Good.
Now I hope that I am visible and audible.
Yes, sir.
It's okay if I start? If I'm visible and audible to all?
Yes, sir, you are. I'm so sorry about this little glitch.
Okay.
Yes, sir, you're visible and audible.
No issue, no issue. So good morning
Yes.
to all of you present here today. At the outset, I would like to thank the Praveen Gandhi College of Law for having invited me to this conference on inclusivity in law. In this conference, you will be discussing various perspectives on inclusivity, such as gender, education, disability, and so on and so forth. I am here today to speak about a topic very close to my heart, that is on the rights of sexual minorities in India and the role that the judiciary has played in defining these rights and how we need to move forward from the point we have reached. Central to the issue of these rights is the focus on individuality and freedom, which our Constitution embodies as a means to achieve the goal for restoring to an individual a control over his own life and destiny. However, decades after the Constitution came about, we still struggle to guarantee these ideals to individuals. The constitutional idea of India still remains a distant dream for so many, the untouchables, the disabled, menial workers, and sexual minorities. We all agree that the lesbian, gay, bisexual, transgender, and queer, or the LGBTQ community, have been stigmatized and persecuted in India for decades. The rights of sexual minorities, whom the Supreme Court trivially called a minuscule fraction of India's population and recriminalized in the Suresh Kumar Koshal decision, came to the forefront first through a public interest litigation filed in the Delhi High Court by the Nas Foundation. How do you decide who is part of a minuscule minority that is worthy of being protected? Fortunately, a lot of this is past history, with the judgment in Nalsa Puttaswamy and Naute Johar, turning the tide positively and setting the stage for deeper questions to be asked and answered around individual rights and freedoms. The case that set the ball rolling, though, was Nas, which raised complex questions of law, religion, morality, health, dignity, and culture, which were discussed at length and in different measures by my brother Judge S. Muralidhar and myself in the first instance and by the Supreme Court subsequently. The case concerned a 150-year-old provision, Section 377 of the Indian Penal Code, that criminalized carnal intercourse against the order of nature. This provision criminalized even consensual sexual acts between adults in private and imposed a punishment of imprisonment for life or imprisonment extendable to 10 years and fine. The exact objective of this provision remains unclear and unsubstantiated. It was probably introduced in British India with a presumption of a shared biblical morality. Historians speculate that there were concerns that not having wives would encourage the Imperial Army, that's the British Army, to become replicas of Sodom and Gomorrah, or to pick up special Oriental vices. Sodom, from which the word sodomy originates, and Gomorrah are referred to as cities of homosexual sin in the Bible, the Torah, and the Quran. While this law seems neutral on the face of it, in practice, it has been used almost exclusively against homosexuals and other sexual minorities. This provision was challenged on constitutional grounds and posed stark questions to us at the Delhi High Court. Why should someone's dignity and ability be judged by their sexual preference? Why should one's fundamental life choices be conditioned by other people's prejudice ignorance, and stigmatization, why should public health be compromised by an archaic and pedantic notion of public morality? And why should a sizable population of Indians be deemed criminals in the eyes of the law simply for accepting who they are? The High Court decision in NAS decriminalized consensual sexual acts and highlighted the issues faced by sexual minorities. Section 377 was read down and was deemed unconstitutional insofar as it criminalized consensual sexual acts between adults in private. The judgment generated much literature and debate. This was overruled by Suresh Kumar Koshal. However, that the Supreme Court's view was slowly changing was indicated in Puttaswamy when, in the completely unconnected privacy matter, the majority decision authored by Justice Chandrachud said that the Koshal decision was one of a few discordant notes in its jurisprudence, placing it in the company of ADM Jabalpur. Finally and formally, the Supreme Court decision in Naute Johar reversed all that had been said in Kaushal. Another key decision of the Supreme Court that played a role in developing this new jurisprudence was its 2014 decision in Nalsa versus Union of India on the rights of the transgenders. In that case, the court affirmed that transgenders had the right to self-identification of their gender as male, female, or third gender as a fundamental right. Most significantly, the court declared that no one could be discriminated against on grounds of sexual orientation. In effect, it accepted and reaffirmed the logic of the judgment in NAS. NALSA was a landmark progressive decision not just in India, but the world over. Europe, for example, is only slowly recognizing the third gender as an official identity option introduced as recently as 2013 in Germany. All the judgments I mentioned speak of lofty constitutional ideals of equality, dignity, and freedom. But this must translate into practice. NALSA, for example, began a conversation around the law about the transgender rights. But the Transgender Persons Protection of Rights Act, which was passed by Parliament in 2019, is one of the most controversial, inadequate, and misconceived pieces of legislation I have seen. Today, I begin with a short introduction on the origins of the criminalization of homosexuality, how it came into India, and how the world has dealt with it. I briefly discuss the NAS case. I then offer my views on the Supreme Court judgments in Kaushal, Naute Johar, and Nalsa, and also the subsequent controversial transgender law. I conclude with my views on how the rights of LGBT community can change going forward. Origins of the criminalization of homosexuality. For millennia, it was believed that humans are born to desire sexual and emotional relations only with the opposite sex, and that this was the will of God or of nature. Anyone not conforming to this norm was perverse, unnatural, and a sinner. The Abrahamic religions of Judaism, Christianity, and Islam traditionally forbade sodomy, believing it to be sinful. English law was thus deeply influenced by these beliefs. In contrast, religions emerging from the Indian subcontinent, such as Hinduism, Buddhism, had a less polarized view on homosexuality. Arguably, their understanding of gender and identity is much more variable and fluid. Temple imagery, sacred and mythical narrative, religious scriptures, and literary texts suggest that homosexual activities existed in ancient India in some form or the other. Clear depictions of homosexuality can be found in the Khajuraho and Konark temples. The Kama Sutra also discusses homosexual acts. References prevail in later centuries as well. Historians offer a more structured perspective on the evolution in societal perception of homosexuality. British archaeologist Colin Renfrew suggests that in earlier mythic times, when religion took center stage, homosexuality was regarded as a sin, moral degradation, and vice. With industrialization and the emergence of the nation state, the economy needed more citizens, soldiers, and workers. It was believed that homosexuals did not contribute to the growth of the nation state as they defy the biological imperative to procreate and were hence subjected to criminalization and punishment. Early psychology experiments regarded homosexuality as a mental illness or disease. Today, however, society's views appear to have reached a rational end, and homosexuality is now regarded as nothing more than one of many variations in human nature. The English law criminalizing homosexuality was imported to India. This model codifying such religious morality was also transported to various other colonies of the British Empire, including India. In contrast, in France, sodomy offence was omitted when its penal code was rewritten in 1810 under Napoleon. And nations influenced by French law also omitted this offence, including Holland, Belgium, Spain, Portugal, Scandinavia, Germany, and Russia, and later even Japan and China. So, turning then to the Nath judgment by the Delhi High Court, I'm reminded of, I would like to tell you a small story. While I was a judge in the Bombay High Court, I met a delegation of German legislators. At the time, any talk about homosexuality even was completely taboo. No petition had been filed either. This delegation asked me if the law could be repealed and whether the courts could do it. In response, I recall telling them that the courts may not be able to handle this issue. Little did I realize that I would someday go from Bombay to Madras to Delhi and then find myself dealing with this issue in the Nas matter. When Nas came up before Delhi High Court, global attitudes towards the criminalization of homosexuality were completely different from 1860 when the law was enacted. In the United Kingdom itself, for example, the 1957 report of the Departmental Committee on Homosexual Offences and Prostitution, better known as the Wolfenden Report, recommended that homosexual behavior between consenting adults in private should no longer be criminal offence. A decade later, England passed the Sexual Offences Act 1967 to replace the previous law on sodomy. Thereafter, laws discriminating homosexuality were repealed in approximately 2/3 of the countries globally. This included all of Europe and most of the Commonwealth, notably Canada and New Zealand. Constitutional courts decisions in Nepal, Fiji, Hong Kong, and Botswana decriminalized homosexuality, besides path-breaking decisions in South Africa, the United States, and by the European Court of Human Rights. As far back as 1990, the World Health Organization announced that homosexuality was not a mental disorder. Presidents of the World Psychiatrist Association and World Organization of Family Doctors have been openly homosexual. The medical case for homosexuality is universally demolished. In law and society too, we need to do the same. In India, however, there is a prevailing view, especially amongst decision makers, that homosexuality is a Western import which has no connection with India. For years, there was an official position that India had no homosexuals, or at most very few of them. Leading administrators, such as the head of the Indian Council of Medical Research, reportedly insisted that homosexuality did not exist in India because it was banned and entailed a serious criminal penalty. NAS came before Justice Murligar and myself in this backdrop of domestic and international developments. The government of India strangely took contradictory position itself. The Ministry of Health and Family Affairs argued that Section 377 was unconstitutional as criminalization drove homosexuals underground and hampered the government's HIV/AIDS program. But the Ministry of Home Affairs supported Section 377 on grounds of public morality, arguing that Indian society was not yet ready or willing for greater tolerance to homosexual practices, and the law could only reflect society's perceptions. The Home Ministry also argued that any challenge to Section 377 would be misconstrued as an unfettered license for immoral activities and would open the floodgates for delinquent behavior. The court answered the Home Ministry by distinguishing between public and constitutional morality. Public morality reflects moral and normative values of majority population. In contrast, constitutional morality derives from fundamental values of the Constitution on the basis of which judges must test the legitimacy of a moral law. Constitutional morality not only reflects majority values, but also shapes and changes them through social engineering. Why we need constitutional morality? A modern democracy rests on twin principles: majority rule and the need to protect fundamental rights. Fundamental rights are inalienable and transcend challenge or limitation. These rights identify subjects, withdraw them from political controversy, place them beyond the reach of majorities, and establish them as legal principles to be applied by courts equally for everyone. The judiciary ensures that a majority government does not override fundamental rights. While law may derive from majoritarian moral beliefs, constitutional guarantees lose significance if they are given majoritarian interpretations. Take untouchability, for example. A class of persons was discriminated against, denied equal treatment, and deprived various freedoms for centuries in the name of religious sanction, merely because of their caste. The Constitution changes by prohibiting untouchability. The Delhi High Court used this to rule that Section 377, though theoretically might reflect public morality, it was against constitutional morality and thus not immune from judicial review. This discussion on constitutional morality, that is secular, respects human dignity, and recognizes the autonomy of free will and freedom of choice and action, is especially relevant today. The phrase is now used commonly in judgments such as those relating to adultery and Sabrimala, for example. In NAS, however, it was used for a limited purpose to distinguish constitutional morality from public morality. Indeed, in Nautet Johar, Justice Nariman picked up on the same concept and observed Section 377 was the product of the Victorian era and 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 with its attendant puritanical moral values, public morality must give way to constitutional morality, as has been recognized in many of our judgments. Constitutional morality is the soul of the Constitution, which is to be found in the preamble of the Constitution, which declare its ideals and aspirations, and is also to be found in Part 3 of the Constitution, particularly with respect to those provisions which assure the dignity of the individual. So what happened after NAS? That was particularly remarkable, for it marked a turning point in public life. When the judgment was pronounced in open court on 2nd July 2009, many present there broke down and wept. LGBTQ groups later held collective readings of the judgment to assure themselves that they were now legal persons who could finally demand to be treated as non-criminals and full human beings as their fellow citizens. The decision itself shaped public opinion nationwide on homosexuality. NAS led to an unprecedented coming out of LGBTQ persons, in many cases, with strong family and parental support. You will surprised to know in Kaushal, parents themselves filed an intervention represented by senior advocate Mr. Parinariman. Another visible change is how the middle class has stopped joking about homosexuals. In many personal narratives written after NAS, homosexuals acknowledge having found the space to express themselves without fear of ridicule or ostracization. Gay pride parades are common celebrations now. The Delhi High Court judgment started an important conversation in this country, one that is spiritedly continuing today, and that is compelling a move away from the language of homophobia towards a vocabulary of choice, personal autonomy, the fundamental right to love, and greater sensitivity towards the variability of humankind. In the words of my friend Justice Michael Kirby of Australia, a minority until recently was hated, excoriated, and penalized is now asserting itself and demanding equal rights in the law as in society. A two-judge bench at the Supreme Court, however, in Suresh Kumar Kaushal, overturned NAS, giving deference to the IPC without engaging in any proper discussion on the fundamental rights mentioned in NAS. Kaushal was, as rightly described by Justice Chandrachud in his Puttaswamy judgment, a discordant note. I will not dwell it upon further, for much water has flowed under the bridge since. With its decision in Nauted Johar, I think the Supreme Court woke up to the foreignness of the IPC. A British politician and barrister Lord Leicester had said, the IPC was not Indian, nor was it a gift from God. It has no divine sanctity. It was the handiwork of the English utilitarians inspired by Jeremy Bentham. Thus, this deference to colonial era law, even when it runs contrary to our constitutional values and our fundamental rights, seems incongruous. Recall that a mere 10 years after India's independence, the UK's Wolfenden report recommended the decriminalization of homosexuality, and the law was finally passed in 1967. So within 20 years of Indian independence, the British, who had brought this law to India, had reversed their stance on homosexuality. The Supreme Court in Kaushal had unduly focused on the non-prosecution and non-enforcement of Section 377 as a ground for not repealing the law, saying that there were not many convictions or prosecutions, and that anyway this was there was a minuscule minority question. But this is a deceptively simple and false approach. Merely because no one is arrested or jailed does not mean that no one is affected. Anti-sodomy laws like 377 have had three direct effects. They damage the psychological well-being of the LGBT community, encourage anti-gay violence and discrimination, and facilitates harassment, blackmail, and exploitation by police as well as society. Considerable harm gets done even with no enforcement. Such laws not only raise possibility of actual prosecution, but also the fear of prosecution and persecution. This causes a chilling effect on for instance, a hesitation in coming out as openly as gay or lesbian. We know so many stories now coming slowly becoming public of homophobia driving people to alcoholism, depression, and suicide. There is now infamous and tragic story of Professor Cyrus, who was sacked from the Aligarh Muslim University on charges of homosexuality and eventually met an unnatural death. A movie was made on this episode. I mean, it's a very well-made movie. You should watch this movie. We must remember and memorialize those stories, for they tell us what even an unenforced law can do. The larger community is slowly waking up to. Justice Lokur, in his NJC judgment, you will recall that there was a law passed by the central government called NJC for appointment of judges in the High Court and the Supreme Court. So that was struck down, and in one of Justice Lokur said that the present political executive not permitting the appointment of a gay judge. And it really happened. A very fine lawyer from Delhi High Court was recommended for judgeship in the High Court. And the Collegium, Supreme Court Collegium also recommended his name, but it's still not happening. I mean, this is the reason, only reason would be that he is a homosexual. Contrast this with Justice Cameron in South Africa, who was appointed to the Constitutional Court, their highest court, after declaring his sexuality. Section 377 is not only example of problematic colonial legacy pertaining to sexual minorities remaining on statute book. The Criminal Tribes Act, there is another law about which I must tell you, that is called the Criminal Tribes Act 1871. This was enacted in colonial law to police those tribes and communities who, according to the British, were addicted to the systematic commission of non-bailable offences. I mean, in Maharashtra, you will know that there are many communities which have been covered by this colonial law. Just belonging to one of those communities, getting birth in these communities, meant that individual was deemed a criminal. In 1987, the act was amended to include eunuchs. The government had to keep a register of all eunuchs who are reasonably suspected of kidnapping or castrating children or committing offences under Section 377 IPC. Nehru, in a 1936 speech, famously called the act monstrous, arguing for its repeal, saying that the whole principle as such is out of consonance with civilized principles of criminal justice and treatment of offenders. Despite its eventual repeal after independence, for the longest time, Hijra community was still criminalized. Persecution also continued. The Nalsa decision, however, was the game changer. In Nalsa versus Union of India, the Supreme Court recognized transsexuals as a third gender. At its heart, the judgment accepted that non-recognition of Hijras, transgender persons, denies them equal protection of law, thereby leaving them extremely vulnerable to harassment, violence, and sexual assault. Contrary to Koshal, the court interpreted sex to include gender identity, to establish a violation of the right to equality. It also extended freedom of speech and expression to encompass values of privacy, self-identity, autonomy, and personal integrity. Nalsa said that even if law were facially neutral, it could be unconstitutional if it had disparate impact and discriminatory intent. The Supreme Court, in its unconnected privacy decision in Puttaswamy, picked up on this changing jurisprudence and identified its caution that two-bench decision as one of the two discordant notes in Indian jurisprudence, the other being ADM Jabalpur. Many of these ideas were developed by the court in Naute Johar. For example, the judgment acknowledged the spectrum, that is sexual and gender identity, with its central recognition of the idea of choice. The decision effectively concludes that choice of identity or individual self-determination and the so-called naturalness of sexual orientation are equally important for constitutional rights. The Chief Justice Deepak Mishra concluded that Section 377 disrespects individual choice, making it both irrational and manifestly arbitrary, and thus violative of Article 14. More importantly, perhaps, is Justice Nariman's view that pre-constitutional laws do not enjoy any presumption of constitutionality. There is a presumption of constitutionality of a law passed by the legislature. He said that presumption of constitutionality means that Parliament is aware of its limitations, it can only enact laws which are in its power to do so. It cannot transgress fundamental rights and other constitutional provisions and so on. But pre-constitutional laws like the IPC were made by foreign legislations and no such presumption exists. Justice Chandrachud critically observed, Justice Chandrachud critically observed that members of the LGBT community are entitled, as all other citizens, to the full range of constitutional rights, including the liberties protected by the Constitution. With the Supreme Court accepting that homosexuality is not criminal activity, there is no turning. But here, the court also recognizes that mere decriminalization is only the beginning. The journey is long and arduous and will involve turf wars of all kinds of basic civil rights, whether it is the right to education, housing, access to services, and marriage. But unlike the situation 10 years ago, the destination is now visible and perhaps even within reach. Many countries have changed laws and set precedent to ensure that the stigma against LGBTQ persons be removed and that non-discrimination and fair treatment are truly available to all. This has taken place at least 3 ways in recent decades in different parts of the world. The first way has been to provide for this in the Constitution itself. For the first time in history, South Africa's post-apartheid constitution was drafted to forbid discrimination on the grounds of sexual orientation. It is interesting to note that Nelson Mandela, under whose watch the constitution was drafted, was not pro-gay rights to begin with. But his opinion was changed after discussions with the younger ANC leadership to concede that gay rights are the same as human rights and no discrimination could be acceptable. Other countries have done the same in their constitutions, such as Fiji, Ecuador, and Bolivia. These are newer constitutions. The second way has been by reading fundamental protections expansively. By 1989, the Supreme Court of Canada had established the principle that their constitution did not provide exhaustive grounds of discrimination. Like our constitution, Articles 14 and 15, the grounds of discrimination are enumerated. But Canadian Supreme Court said, no, these grounds, the grounds analogous to those enumerated are also covered. In the 1995 case of Egan versus Canada, it's a very leading judgment which is also referred to in NAS. The Canadian Supreme Court extended the analogous grounds doctrine to LGBTQ persons as well. And this doctrine is extended to many other type of cases. Our Supreme Court accepted this in Nalsa, powerfully concluding that discrimination on the basis of sexual orientation or gender identity, you are going to, this is one of the topics about the gender is also one of the topics. So this is a very important judgment. Includes any discrimination, exclusion, restriction or preference which has the effect of nullifying or transposing equality by the law or the equal protection of laws guaranteed by our constitution. The third way has been by passing or amending national laws that explicitly prohibit discrimination against LGBTQ persons. Examples of this abound, notably the United Kingdom, Australia and New Zealand. And what is important is that some of these laws are not only about LGBT, but they prohibit all discrimination, it has gone the ground of race, caste, gender, anything. And these are very specific laws. And in fact, I was a member of a group which drafted an ideal law for India. I mean, this was, I think, around last year, I think. And this was sent to the government of India. And there is nothing heard from them, of course. So this is the third way of protecting the rights of the avoiding discrimination or defeating discrimination against on various on these grounds. So the UK's Equality Act of 2010 makes this provision. So wherever basic rights of LGBTQ persons have become entrenched and recognized, jurisdictions have moved on to explore how such persons can be mainstream in society. See, even for disabled, we are going to discuss disabled. So how do you mainstream a disabled LGBT community or others how do you mainstream them in the society? After recognizing same-sex relationship, the next step has been to recognize formal civil unions or partnerships between same-sex individuals. This issue is now about the partnerships. I think one judgment of the Allahabad High Court has said they granted them protection to the couple, same-sex. That was not a case of marriage, however. The underlying principle is not to provide any kind of special status to any group of persons. You must keep this in mind, whether you are dealing with LGBTQ or disabled people or anyone. So you are not giving them some special status. All that you are doing is giving them the same rights as are available to the other persons. At the highest, there will be some affirmative action under Article 15 of the Constitution. So it is to acknowledge that social institutions like marriage, child rearing or family life are neutral to sexual orientation or gender identity. The issue of same-sex marriages is already pending before the Delhi High Court. Unfortunately, the central government through the Home Ministry has again taken the stance that same-sex marriages will cause havoc with the delicate balance of personal laws, echoing public morality argument it had made earlier in the last case. However, in the light of the Supreme Court's binding decision in Nauted Johar, the Delhi High Court would find it difficult, if not impossible, to take a negative view on such marriages. The 2015 US Supreme Court decision in Obergefell versus Hodges is relevant here. This petition challenged laws in 4 states in the US which defined marriage to be only a union between a man and woman. The court concluded that the fundamental constitutional right to marry is guaranteed even to same-sex couples, thus overturning 1971 decision and effectively legalizing same-sex marriage throughout the country. So we are at a juncture when the legislature has to step in and play its role. It has tried that with the Transgender Act that the Parliament legislated upon after a few iteration, although with disastrous results. I'll just speak briefly about the transgender law. Any law that seeks to address the rights owed to transgenders must recognize the grave wrongs that have been done to them. Merely for their identity, they have been killed, raped, stripped naked, and brutalized to a degree that is indescribably horrific and traumatizing. There were affidavits filed before me in Delhi High Court by several people. I mean, there was one affidavit by a transgender, his family rather, about what the police did to that person in the Madras High Court, where a transgender immolated himself in front of the police station after so much of harassment. And so I allowed that petition and granted compensation to the family and asked the government to take action against the police personnel. So the consultation, your first step should be recognition. You must consult the stakeholders, that is the transgenders themselves. But the consultation for the 2019 Act was thoroughly inadequate. The bill itself was made available to the public on the day it was presented in the Lok Sabha. So there was no prior consultation. Naturally, for a law that was made without appropriate consultation, it has several problems. Several definitions are redundant and inapplicable to the issue of the community. I'll give you a classic example of the term family. The law blindly borrows the definition from earlier laws without understanding its relevance to the transgender community. Most trans persons do not live with their biological family due to discrimination and violence. Mostly they are thrown out of the family. Thus, the idea of a chosen family becomes relevant. Since the chosen family provides support, the chapter on decriminalization against transgenders ought to be the centerpiece of the law. It has its own problems. There is also no enforcing authority. There are no remedial measures by way of compensation or otherwise for survivors, and there are no serious punitive measures against violators. The National Council for Transgenders is a council to take all decisions about transgenders. It consists of 30 persons, and out of 30, only 5 are transgenders. So you are supposed to give benefits to that community, but their representation is so small on your council, and the council is nominated by the government. You can imagine what kind of council will be nominated. Prime Minister Narendra Modi has on occasions acknowledged that transgenders have been treated unjustly in India and that the government needed to change its outlook, including thorough changes to its laws and regulations. But changes are meaningless if they fail to recognize the real issues that are faced by those affected the most. Even so, we must remember that the battle to safeguard the rights of LGBTQ persons will not be won simply by political or judicial action in reviewing a certain law or creating a new legislation. The battle will finally be won when everyone in India, in cities or villages, in police chowkis or hospitals, will truly believe that LGBTQ persons are no different, that they have the same capacity to love, build long-lasting relationship, and be good parents as everyone else. On our part, we can help by spreading awareness and by treating LGBTQ persons with equal kindness and consideration. Finally, I believe a couplet from the great Persian mystic poet Rumi, I believe that some of you might have read his poems, captures succinctly what I've been trying to say all this morning. Listen with ears of tolerance. See through the eyes of compassion and speak with the language of love. So this is how Rumi puts the thought. And this should be your message of your today's conference, that you must keep your ears open, be tolerant. Whenever you see misery, you see it with eyes of compassion. And whenever you speak, you must speak the language of love. So with this, thank you for this inviting me again. Thank you very much.
Thank you so much, sir, for the wonderful session and your kind presence. So I, Yashish Prajapati, on behalf of SV Games Praveen Gandhi College of Law, would like to express our sincere gratitude to you for this enlightening keynote speech. Thank you so very much, sir, for sharing your valuable ideas on the concept of inclusivity and the need to make laws more inclusive. Thank you so very much, sir.
Thank you all. So now I'm going to say bye to you. Thank you.
Thank you very much,
Thank
sir.
you so much for
And
joining us.
Thank you, sir.
I would now request my co-host Nawaz and Khushi to take over.
Thank you so much, Yashish. Um, it is my honor and pleasure to be able to introduce Professor Dr. Sebastian Michael. Professor Dr. Sebastian Michael is the director of the Institute of Culture in Mumbai. Sir is the Emeritus Professor and the Adjunct Faculty of Cultural Anthropology, University of Mumbai. Sir has held several academic responsibilities as the Mumbai University, as the exam coordinator for sociology and a member of the Research and the Recognition Committee. At present, Sir is also a part of the Research and Recognition Committee for Anthropology at the Savitribai Pune University and of SNDT University, Mumbai. He is a visiting faculty at the Anthropos Institute, Bonn, Magdeburg University, both in Germany. He is also the member of the College Development Committee of College of Social Work, Nirmala Niketan Fort, and St. Andrew's College in Bandra, Mumbai. Amongst his several books, the edited volume of Dalits in Modern India, Visions and Values, published in 1999, was a bestseller at Sage Publications. It has been translated into several languages. Other books by him are Anthropology as a Historical Science, published in 1984, Culture and Urbanization in 1989, Globalization and Social Movements, published in 2003, Integral Anthropology, published in 2012, The Humanistic Relevance of Anthropology, published in 2017. He has successfully guided 19 PhD scholars in the field of anthropology and sociology. Recently, he has also been appointed as rector of the newly opened St. Arnold Degree College at Andheri. Sir, I invite you to share your conceptual fundamentals of the theme of the conference. Thank you.
Thank you very much for your introduction about me. Honorable scholars, legal luminaries, students, and friends. First of all, I am very grateful I have been called to give an introduction to the theme of the conference today, Inclusivity in Law, Multidisciplinary Perspective. So, as correctly pointed out, I am not a lawyer. I am not in the judicial perspective or in the realm of law and governance, but I am an anthropologist and sociologist for a multidisciplinary perspective of inclusivity in law. Such a person from outside to think about legal issues is good, and I am very grateful for that. Having said that, I am not an expert in law, but I would like to say that law normally is understood as regulating the society for a harmonious, peaceful living. But at the same time, there is a perspective or an opinion. The law is always a very forceful and binding and taking the freedom of the people. But it is not necessary. But we need to use our power in society in such a way that all human beings are able to attain their potential, and certain kind of regulation are very important, and that is the role of law as I understand. But at the same time, the laws are enacted for the fulfillment and joy of humanity. So every society has a vision how the members of the society must be. So what we see, the vision of the particular society articulates itself and formulates itself into several laws. When we come to India, we begin to see India is a multicultural, multilinguistic, multi-religious, multi-ethnic society, where we begin to see people from all kinds of races, say starting from Northeast India, the Mongoloid influenced group, to Caucasoid influenced groups, and the various streams of mixtures of these racial groups are found in India, and also various language groups. And so in this context, our founding fathers had a vision for us, the citizens of India, that we all should enjoy the freedom and also to fulfill our human potentialities. So with a long struggle during the course of our freedom struggle, they arrived at a constitution which is inclusive of all the people of India. We, the people of India, give it to ourselves, a constitution. So this constitution visualizes whether you are a tribal, whether you are as we sing our Janaganamana, the various groups, the Dravidians, the Marathas, whatever groups, we all must enjoy equality and freedom to reach our potential. So this constitutional vision is given in practical terms in various laws. So then what we see, as Honorable Justice A.P. Shah pointed out, that we need to reach, there is a long time for us to reach the vision of the Constitution of India. So in this context, when we are talking about inclusivity in law, we need to take into consideration this pluralism of multiculturality, multi-religious, multi-ethnic, multilingual reality of India. But at the same time, our law should channelize our energy in such a way that we all are able to realize our potential. Lastly, I would like to say, in our inclusivity, we need to take into consideration the gap between the rich and the poor, the tribal situation, the tribal aspiration for their culture, for their language, for their identity. I think in India, we need to go a long way recognizing the rights of the tribals. Similarly, we see the caste discrimination. I am only touching upon the paper. I see there is a paper on gender inclusivity. There is a inclusivity in education between urban and rural. Then we also got papers on accessible inclusive environment for education for disability persons. So I am not touching up those points, but I am pointing out a very important aspect in inclusivity, the tribal aspiration, the tribal culture, the tribal identity, and also the caste discrimination, the aspiration of the Dalits. No? So we need to also look into how our law can bring justice to all people, including the Dalits, and also certainly women is covered here, and religious minorities, linguistic and cultural groups. So we need, our law should be inclusive one, taking into all these into consideration. I highly appreciate the Honorable Justice A.P. Shah gave his keynote address taking one of the aspects of transgender, how the law can be reformulated to give equality and justice to them. Similarly, as I pointed out, for our tribals, for our Dalit brothers and sisters, our religious minorities, linguistic and cultural groups, they all need to get justice and they need to be in inclusivity in our law. So with this small introduction, I wish you all the best for your one-day conference on this inclusivity in law. Thank you very much for giving this opportunity. Thank you.
Thank you, sir. I'll take this moment to thank Professor Dr. S.N. Thomas, who spared time from his busy schedule to grace the occasion and introduce the theme to us. We had the opportunity to hear from you today. Once again, thanking you for your presence.